Good morning. Good morning, everybody. I'm your host, Supreme Litigant, and I'm back again with another video. If you haven't already, please go ahead and subscribe to my channel and hit that like button. I told you I was going to give y'all a video, make y'all a video about how to draft a motion, and that is what this video is. It's going to teach you how to draft a motion. Uh, Generally speaking, all motions are pretty much drafted the same way, but in order for you to draft the motion that you want, you need to read the Federal Rules of Civil Procedure since you're going to be litigating your federal lawsuit against the police or whoever it is in federal court. But preferably, if it's the police, do it in federal court. So you want to use the Federal Rules of Civil Procedure. So let's say you filed your lawsuit, they've answered the complaint, and now you have to issue a response to their answer. Well, let's say that they filed a motion to dismiss to your complaint, and so now you have to file a response in opposition to their motion to dismiss. And you're coming up on the deadline, and you don't think you're going to make the deadline. So let's say you want to get an extension of time. You want more time from the court. Okay, you can get that. What you need to do is you got to read these rules. Okay, so let's find the rule that allows you to motion for time for an extension of time with the court. It looks like it's here, Rule 6, computing and extending time. So we're going to click that, and then you read the rule after you click it. Let's see, computing time. I don't think it's A. It's got to be subsection B, if I'm not mistaken. There it is. Yeah, it's subsection B. So it's Rule 6, B, one in general, one in okay, B1. So what you want to do is, let's see, you comes now, John Doe. We're going to use John Doe as an example here and after plaintiff. That means John Doe throughout this document is now referred to as the plaintiff throughout this entire document on down here. So it was Rule 6. So we're going to say Rule 6. What was it? B1 of the Federal Rules of Civil Procedure. This is how I do my stuff, y'all. I'm very detailed with my paperwork and with my documents. So I like to highlight stuff, bold stuff I meant, for y'all to see. Let's see here. For an enlargement of time on the following grounds. Now, there is a standard for this. All motions, generally speaking, have standards that the court set in order to determine if the motion will be granted or denied. But this here, I don't want y'all to put too much thought into it. This is just going to be an example video. This is just a standard sample video of showing you how to draft a basic motion for the court. So here it is. Comes now, John Doe, hereinafter plaintiff, pursuant to Rule 6B1 of the Federal Rules of Civil Procedure for an enlargement of time on the following grounds. And then you state your grounds. Plaintiff's motion is drafted and submitted in good faith for good cause. Plaintiff's motion would not prejudice any party in the case sub judice by the extension requested. Plaintiff's motion is neither intended to unreasonably nor unnecessarily delay the case sub judice. These are just examples that you can use. Okay, and if the opposing party disagrees with you, I promise you they're gonna let you know. I promise you, they will let you know. Let's see what else we missing here. We'll go down here, and we're gonna say that these are the only grounds that you have. So we're gonna end this here, and we're gonna put a signature line right here. And let's see, I like to do mine like this. So we'll say John, spacebar John Doe, and then we'll just add some more of that on out. John Doe, that's the signature. Then you can put your name. Of course, you can put your name and pro se, all that stuff up on the address and all that right under here in this section. You also want to make sure you do a certificate of service, which is pretty easy. Just to, certifying that you've served or furnished a copy of this motion to all the attorneys of record, meaning all of their attorneys who you sued. I mean, for the defendants who you sued. Also, when you see this right here, it says plaintiff's first motion for time. I strongly advise y'all to put stuff like this in your documents because you may need to draft an additional motion for time. And let's say you want to draft another one, and you would just simply say plaintiff's second motion for time, a third motion for time, a fourth motion for time, stuff like that, so you won't confuse yourself and so you won't confuse the court. This stuff is pretty easy, y'all. It's not hard. You can do this. If you wanted to draft a motion for summary judgment, you would, let's see. We're going to say, we're going to do this. We're going to call it plaintiff's motion for summary. Of course, you would need to edit this. So you would go here and you got to read the rules. I think it's rule 56 for summary judgment. 56C or something like that. Let me see. Scroll down through the rules. You got to read the rules. Judgment. Here we go. There it is right there. Rule 56, summary judgment. Okay, motion for summary judgment or partial summary judgment. A party may move for summary judgment. There you go, right there. So you would basically rule 56A. You go here and you type in rule 56A of the Federal Rules of Civil Procedure. And you can say for summary judgment. Let me get that out of there. I think that's what I did up here too. Summary judgment on the following grounds. See this? On the following grounds. Of course, you would need to delete this. You would state your reasons. Now, when you're doing a motion for summary judgment, all of the evidence that you have gotten through discovery, you're going to use that evidence in support of your arguments on why you believe that you are entitled to judgment as a matter of law when you're motion for a summary judgment. But all of this stuff is pretty easy. You see how I just changed that motion for time to a motion for summary judgment just by doing that? Plaintiff's motion for summary judgment. What you can do, you can say plaintiff's first motion for summary judgment because you may need to do another one. You may get denied on some of your claims for summary judgment. You may want to do another one, or whatever. This stuff is easy. It's not hard. Let's scroll up a little bit. I want y'all to see some stuff. This is pretty much standard how like you can just copy and paste this in every document. In your court case, your title, the caption of the case and all, you can just copy and paste that through every document in your court case because you're going to use that throughout the entire case. So this is the court in which the case is being held in, right here, the name right there. These are the parties to the case right here to your left, to my left of the screen right here. These are the parties. And this would be the case number right here. And all this stuff is easy, man. Y'all can do this stuff, man. It's very easy. On the following ground, you're doing this for everything, even if it's a motion to dismiss. Doesn't even matter. If you're in state court and you filing a motion to dismiss because the complaint that this police officer has filed against you is devoid of the prerequisite elements of the offense, it's vague, it's conclusory, and it's legally insufficient as a matter of law, shit like that, you just file a motion to dismiss. And all you have to do is just, erase this You would change this. You know, you can either bring it by a rule in your state court, blah, blah. It doesn't matter. You get the point what I'm trying to tell y'all to do. This stuff is not hard, and you can do this. I think this video should help y'all. Okay, if it doesn't, let me know, and I'll try a different approach. But this is pretty easy. It's pretty simple and straightforward to the point. So hopefully this video helps y'all. Go ahead and hit that like button if you haven't already. Thank you.